Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. Okay, today I will tell you about how to stop injured vessel crew from calling my law firm. It was published on August 29th in 2022. For 20 years, I represented operators of OSVs, jackups, semi-submersibles, oil and gas production platform, harbor tugs, towboats, and purchase instead, and federal court personal injury in litigation arising in the Gulf of Mexico. Across the Great Lakes and on the inland waterways for the last decades or so, I have been representing injured crew. In the case of a death or serious injury, sometimes there is a little vessel operator can do to prevent being sued. In my experience, though, many expensive lawsuits could have been avoided had the marine employer handled the situation differently. Number one, treat the injured workers as you would treat a close family member. When a vessel crew member is injured, they become to the claims personnel at many companies. Diamony, a liability, someone to manage, surveil, and treat with suspicion. While I understand some companies may have experienced exaggerated or even manufactured claims, and so their court is up. When every injured worker is treated with disrespect and suspicion, the company sets a tone company-wide. Co-workers of the injured workers witness how poorly their colleagues are treated and quickly realize they are not all valued team members. As the company newsletter proclaims, if every manager in the company afloat and ashore would instead treat injured crew member in the same manner as they would treat a close family member, a different positive tone would be set company-wide. The injured worker and his or her family are more likely to understand accident happen and work with the company through the aftermath if they are treated with care and respect. A company does this by making it clear through their word and action the company's primary concern is for the injured workers to receive as soon as is reasonably practicable the best and most appropriate medical care available. And then number two, do not downplay the injury. 46 CFR Section 4.05 Part 1A6 mandates that immediately after the addressing of resultant safety concern, the owner, agent, master, operator, or person in charge shall notify the nearest sector office, marine inspection office, or Coast Guard group office whenever a vessel is involved in a marine casualty consisting in an injury that requires professional medical treatment, and if the an injury that requires professional medical treatment or treatment beyond first aid, and if the person is engaged or employed on board a vessel in commercial service that renders the individual unit to perform his or her routine duties. I have routinely litigated cases where the vessel captain or pilot immediately reported the Coast Guard reportable injury to shoreside management. But then management just not to notify the Coast Guard. I have seen this mindset to downplay the injury then manifests itself in how the injured worker is treated. Instead of immediately evacuating the man or woman to an emergency room, the worker is often asked if they are okay with riding the boat for several hours until the vessel arrives at its next intended port. Most injured workers want to be a team player, so they will typically not object. Nevertheless, the injured worker gets the message the company has sent. Even though you are so badly injured you cannot work, and even though you are in serious pain, it would be most efficient and cost effective for us if you wait several hours. Would you do this to your spouse, son, daughter, father, or mother? The injured worker and his or her family quickly learn the company's schedule and dollars take priority. The injured workers and their family then start thinking they need a lawyer to receive appropriate medical care. I have received such calls for help numerous times. Um, why do companies do this? Some companies have a bonus program where the lack of reportable or lost time injuries factors into the bonus all employees receive. Some companies want to protect their injury statistic. Some companies think the injury will just go away. Some companies send workers with seriously injured backs to a chiropractor instead of to an orthopedic surgeon who would have ordered an MRI which would have identified a herniated disc. In downplaying the injury, the company has alienated the injured crew member and his or her family. And by not reporting the incident to the Coast Guard, the company has also implicitly told this agency, which often learns of the marine casualty anyways. This company will try to hide reportable event on their vessels and thwart the federal government's investigation. And then number 3, try to find less strenuous work ashore for the injured crew member. There is no light duty work on commercial vessels. In the event of an emergency, all crew members must be able to assist with work like launching a lifeboat, handling a charged fire hose, and assisting with recovering crew who have fallen overboard. But if a company has an injured crew member who is a good worker and they will recover sufficiently to continue to be able to perform, albeit in a less strenuous role, why not continue to employ them? And tell the worker this is the company's sincere plan while the worker is still recovering medically. What would you do if you were making good money, were injured on the job and could then no longer provide yourself and your family? And then number 4, stop underpaying and fighting maintenance and care. Maintenance and care is similar to what shore-based injured workers receive via state workers' compensation laws. Their medical bills are paid and they receive money to continue to be able to make ends meet. Some companies have short and long-term disability plans, which is the financial strain of a workplace injury. Many do not, and thus they only pay what the General Maritime Law requires: maintenance or the seaman's reasonable living expenses, and care or medical care. The problem is maintenance is minimal. It never covered an injured crew member's actual living expenses, including vehicle loan payments and auto insurance. Some companies make supplemental wage payment to injured crew member in exchange for an agreement to receive a credit toward lost future wages in the event of a lawsuit. But most injured crew members don't receive STD, LTD, or supplemental wages. They cannot pay all their bills while recovering from their injuries. They watch helplessly as their truck is repossessed. Some companies try to restrict for what What doctors their injured crew and can see and wear, sometimes improperly requiring the seamen see the company's choice of physician several hours from the worker's home. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe to the channel. See you in the next video, and bye-bye.